else we have online. Good evening, everyone. How are you?
Good evening.
Good evening, Professor.
Good evening.
So many of you online and not so many of you in the classroom. It's really a pity, but never mind. The important thing is that you are there. I can see Yelena. Who else? Saiful, I already noted your presence. We have Una, we have Alexander, and a new student from Germany, Martin. You are an Erasmus mobility student like Myla and Anastasia, who are here with me in the classroom.
Yes, that's right.
Great to have you. Welcome. I'm addressing, directing this especially to you because the rest of the group, I do already know. We had a chance to work together within another course, International and EU and Gender Equality course that was delivered in November and December. So welcome. Hope that you will be enjoying this course. This must be Dushanka. I knew it. Yes, we have also Dushanka. Welcome, Dushanka. And the colleague from Somalia.
Yes, I heard you.
Hello. Sharmarke. Is that the right? I pronounce your name correctly?
Yeah, you're right. Yeah.
Okay, because you were not present at any of my classes within the other course.
What did you say? I didn't hear your voice.
I cannot hear you if you are.
I'm outside, so I was come back for work for home. So
Okay. So let me just close the door because it's rather noisy outside. And I think that we can slowly begin because we are all here. Ksenia is the only one missing, but she sent an email to me today saying that she is abroad on a business seminar, so she won't be able to attend the lecture this evening, but the others are here, so we can start. Hopefully everything will be fine with sharing the PowerPoint. But I have Dushanka here, so now I'm more relaxed than I used to be because Dushanka solves technical issues. Can you see it online?
Yes.
Yes.
We
Great.
can, yes.
Great. Because I will have the PowerPoint on my screen as well, and I cannot see you all who are online. So if you raise hands or want to speak, I won't be able to see it. So in case you have any comment, any question, want to interfere, interrupt, just unmute and start talking, okay? Fine.
Okay.
Great. Mm-hmm.
And that's one of the lights.
Yeah. Feel free to do whatever you like.
Right.
Yeah.
So,
And I think that something happened with the projector because it's better. It's great. Excellent. Thank you. But something happened. The letters were not more clear the last time I worked here in this classroom. I will have to no. I will have to tell our IT department to do something about it because. Am I right? I mean that the letters are not are a bit blurry. Yeah, they're not clear enough. Okay, so you could have also seen it from the working schedule that Professor Marinkovic sent to you in his introductory mail. So the topic that we are going to discuss this evening is the gender dimensions of contemporary forms of slavery and human trafficking. I don't know how much and whether you are familiar with the phenomena of human trafficking. But generally, what would you say? What's human trafficking? Because slavery, you know what it is. I mean, this is also a very old phenomenon, something that we had throughout history. But human trafficking is something that still exists, unfortunately, and it is considered a modern form of slavery. But how would you describe it? What would you say are the most important elements of this phenomenon? Mm-hmm. Anyone online?
I would maybe say that it's an organized chain. It's never like an isolated case. And it's like exchange for money, for some valuable stuff, but usually money. And persons who can be victims in this case can be male, female, but also children and babies. We had the case in Serbia with selling missing babies. So yeah, I would say that it's an organized chain, organized group who is doing that probably, and exchange for money.
Okay. Do you think that it actually needs to be an organized group who does that for crime of human trafficking to be conducted?
doesn't need to be because it can be centered around the neighbor. And if there are people from abroad to work here and live here, the trafficking part will be using and taking their passports and not giving them their passports. So that can be with one person who doesn't see this taking passport as a form of trafficking, but form of control. So I mean, it is trafficking.
Yeah.
Because it doesn't.
That's right. So as you will see later on, it all started at the universal level with this concept of transnational organized crime, criminal groups who were actually conducting human trafficking crimes. But it does not necessarily have to be either an organized group. You can have one single person having another person under complete control and exploiting that other person. And it does not have to be transnational. You can have it within the boundaries of a single state. So where a person is recruited by either a person or an organized group and then exploited. So as you will see, the phenomena of human trafficking, which is both a serious crime and a serious violation of basic human rights, is now well defined in international legal instruments, and I will come to that later. But just generally, I'm curious. Do you think that this could never happen to you? That you would never, ever become a victim of human trafficking? Can you be certain and say, no, this is something that would never happen to me?
I think that's a hard. You cannot be ready to be trafficked. It's not you're not willing to be trafficked. So I mean, you can be trusted, and then
or you can fall in love. You can fall in love with another person and in that way be recruited. Or, even I'm married. I mean, I won't that easily fall in love with another man, but just let's suppose I get an email, which is very tempting, saying that there is a scientific conference or being organized this place or other, and that it is a topic that I'm specializing in, and then I, take the bite and I go there and simply disappear. The point is, this can happen to anyone, but, and this is something that we are going to talk about today, some people, some even categories of persons are more vulnerable to becoming victims of human trafficking. And when it comes to women, which is what is of interest for us within this master program, there are strong gender aspects, gender dimensions of this crime. But let's go from the beginning. I will, as you are used to, send you a presentation, the one that I'm using right now. And you will see that at the first slide, you have a video on YouTube. This is a person, this is one young girl who was a victim of human trafficking here in Serbia, in Belgrade. And the video is about her. She is the one who will, at the beginning of the video, be actually reading the judgment of the Constitutional Court of Serbia, the first ever judgment in which the Constitutional Court of Serbia found a violation of the prohibition of human trafficking, which is listed in the catalog of basic human rights in the Republic of Serbia. She will be talking in Serbian, but there is a translation into English. So also our colleagues who are not Serbian nationals will be able to understand what she is reading. And you will see that she's not able to read because she will start crying because of how traumatized she is with the whole experience. The trial, different degrees of trials, first degree, second degree, etc. It lasted for years and years. Several judges were replaced, several prosecutors were replaced. And to make the things even worse, she was supposed to tell the same story, what happened to her, like 17 times, all over again. Just imagine how traumatized she must have been and going through secondary victimization every time she had to tell that story again to a new judge or to a new prosecutor. So this Constitutional Court judgment was a big victory for her and for the NGO Astra, who was representing her in these proceedings. But please, it is short, it is 10 minutes long. Take some time and take a look at it, because you will get the idea that what we are talking about today, behind everything, those are real persons, victims who have suffered and are still suffering a lot. Okay, so that is why I put this video at the beginning. What we will be discussing today, basically there will be 3 segments of my presentation. First, we will go through some general aspects and talk about old and modern forms of slavery, but also about old and modern phenomena which contribute to slavery-like practices. When I say slavery-like practices, I mean both slavery in the traditional sense of the word, but also some practices which are similar to slavery, but do not necessarily include property over a human being, which is the definition of slavery. And of course, human trafficking, which is, as you will see, very specific because it needs to have these specific elements, including exploitation of a person and recruitment, etc. Then what we are going to do next is to see what are the rules of international law, which international treaties are relevant for prohibition of slavery, slavery-like practices, and human trafficking, and whether they are gender sensitive. So to what extent their provisions actually include this gender perspective and require states to take into account the gender dimensions of slavery and human trafficking while providing, for example, protection to victims or taking different measures to prevent slavery and human trafficking. And for the end, we will be actually questioning the effectiveness of the protection of the international system, mainly through 3 case studies that I prepared. So as you will see, these are real cases. 2 of them are cases before the European Court of Human Rights. And the third one is a case before CEDAW. You are familiar with CEDAW. I know that LOGEM students are, but I'm addressing this question to Erasmus students. So the Convention on the Elimination of Discrimination Against Women. It is also relevant for human trafficking. As you will see, it has a very specific provision, Article 6, which deals with it. And there is one case that's related to human trafficking. But let's start with this general introduction. So you can see here several photos. They are also blurred for the 3 of you who are here in the classroom, but I hope that you can guess what's behind it. And you can see some black and white photos, something that we usually associate with slavery. When we say slavery, we usually think about those old practices throughout the history, when, slavery was actually something considered legal. On the other hand, you have some pictures, some of them very much resemble these black and white old photos of slavery, but some are very, very different. And still, we're talking about slavery-like practices and even human trafficking. So my question would now be, can you maybe compare these traditional slavery practices with these new ones, the modern ones that we still are facing today? Just imagine, the whole concept of human rights protection, it began with the prohibition of slavery. So human rights started to evolve with this topic. Back in 1926, you will see within the League of Nations, the first anti-slavery convention. And still we are talking about it today. So it's not extinct, it's still present. But can you can you give me a comparison between these old slavery practices and the new slavery as phenomena? Those who are online are also welcome to participate. Just unmute and start talking.
More nuanced in terms of not as visible as
visibility. Excellent visibility.
And also because here are the pictures, the fifth one, they are getting paid.
Excellent, Dushanka. Excellent.
And that amount is really not enough for them to live. And also the slavery is not having a property of one another, but also not giving them a possibility to have a common break, or to have lunch, or to have a minimum wage. So it's more nuanced than that.
That's right.
It's more.
That's right.
Invisible, and you need to dive in to understand.
Yeah. Visibility, a very important aspect in numerous regards. Once upon a time, you had slaves in the street, with chains, because that was considered a legal practice, in line with law. Now you have a simulation of situations which appear to be legal, like the one we have here. People seem to be working, earning their salaries, and yet slavery-like practices, even human trafficking, can be actually behind this. Relationships between people, they can also seem like a regular relationship between a girlfriend and a boyfriend or members of the family, and still you can have slavery and exploitation and possibly even human trafficking hidden behind those relationships. Another aspect, how do we define slavery? Through which concept? Not necessarily labor. Labor is something that slaves were usually used to do, the way they were exploited. But what?
Exploitation,
ownership. Excellent, Jelena. Ownership. So slavery is still defined through ownership. So the slave is a person over which someone else is having either all or some of the elements of ownership. Whereas with modern forms of slavery, we do not have ownership anymore because this is not considered legal. But what do we have? Exploitation that was mentioned. And in order to be able to exploit someone, what else do you have to have over that person? You do not have ownership.
control.
But control. Excellent. Who was the one who said that? Yellen also.
Una.
Excellent, Una. Excellent. Sometimes your names, pop up here so I can see, but now it did not happen. Great. So control is now crucial. Methods of enslavement. Back then, what was the main method?
Violence, but now I think that its ownership is gained by, for example, taking the passports and limiting the opportunity to run away and to leave the country.
That's right. Coercion and also abuse of vulnerability. That is something that is now very much an element of modern slavery. What about duration? If you take that as an element to compare old and modern slavery-like practices, back then, in old times, you are a slave for the entire life. It's very difficult to stop being a slave. So this was a permanent, even a position that was inherited from parents. Whereas now this may be temporary, but unfortunately, why temporary? Because a person usually who is, either trafficked or exploited in a way gets out simply because of the fact that it is not of any more use to the controller, to the abuser, to the trafficker, to the one who exploits the person.
Can I ask something?
Yeah, of course.
Would you consider during the World War II Jewish people in work camps? Would you consider them as slaves or no?
You will see, I will go through the presentation and I will give you the legal definition of both slavery, forced labor, and slavery-like practices. So let's then go back to your question and you can also tell me what you think. So whether all those elements from the legal point of view that need to be there are there. And I will also share with you my opinion, okay?
Okay.
Great.
I want to add in the term of similarities and differences through a time that maybe the normalization of slavery. Of course, nowadays slavery as authentic form is not normalized. It's forbidden, and maybe also another ways of slavery, similar practices, but also then some forms are. So I would say it is a difference, but it's also a similarity that sometimes those practices are normalized in the society.
Excellent. Una, thank you. What about the money? What about the economic value, the economic cost, which is what people are nowadays very interested in? I mean, this is a highly, of course, profitable business. But from the point of view of getting a person who will be enslaved in some way, what is the difference? In the old times, slaves were quite expensive. I mean, you would have to give a certain amount of money to buy a person. And today, it doesn't cost anything. Traffickers simply use different either coercive or manipulative actions to recruit persons and then exploit them without any cost. This is simply profit for them without any cost. Okay. So at this slide, this is what we discussed. You have more or less, we mentioned everything, but even though those issues that we did not have time to mention, you can go through later on. But you can see that although they are very, very similar, there are quite some differences between the old and new practice. Now, numbers usually tell us a lot. And this is what I tried to do with this slide. So try to guess what's behind these figures. The first one is 50 million. Do you have any idea what is behind this number of 50 million? Excellent. Anastasia, right in the center. The first answer and the correct one. So if you who are online could not hear Anastasia, she said that this is actually the number of persons who are in some situation of modern slavery today. Actually, this is the data coming from International Labour Organization. It is not that up to date. It is from 2021. There haven't been some more recent information, but still, I mean, the number is terrifying. We would all agree. What about this 25 million? Any ideas what's behind 25 million? No. No. What did we mention? What did I mention as the modern form of slavery? What did I qualify as a modern form of slavery? Human trafficking, whose element, the most important one, is exploitation. So half of the number of people who are in some form of slavery today in the world, half of them are victims of human trafficking. So you can see how widespread this phenomena actually is. $150 billion. So we're talking about money. This is rather easy.
I don't know if it's gain or loss. That I don't know how we.
Depending from which side you are. Yeah, I mean, whether from the side of the trafficker or from the victim. But this is actually the profit that human traffickers gain every year. Just imagine how profitable this endeavor is. So they earn $150 billion a year. Of course, these are just estimates. But you can just imagine that even the figures are even more terrifying. Now let's go to the second column, 60%. Any idea what's behind 60%? Now, Anastasia, something that you mentioned earlier, repeat it. So 60% is actually the percentage of women victims of human trafficking. So if you compare a total number of victims of human trafficking, 60%, so more than half, are women. But the percentage keeps rising on my slide, and you can see that the next one is 77%. What is 77%?
Percentage of people from global source.
No.
Nationally?
No. Who is especially vulnerable to human trafficking? Of course, today we're talking about women, but another very, very vulnerable category. Children. Kids. So if you have in mind the total number of trafficked children, 77% are girls. Girls. So this column is supposed to give you the hints on the gender aspects of human trafficking. And the last one, the highest one, 91%, what does it mean? Human trafficking, you know, one of its elements I already mentioned, and you will see later, is exploitation. So exploitation can have different forms. There is labor exploitation. There is exploitation for domestic work. There is exploitation for taking human organs. So this is also kind of exploitation. But there is also sexual exploitation. In 2030. I know that Law Jam students are familiar with SDGs, Sustainable Development Goals. But for you who are Erasmus students, are you familiar with SDGs? So the goals that were set within the United Nations at the level of the international community to achieve certain goals by 2025 or by 2030. The goal was to erase trafficking in children by 2025. Which year are we now living in? 2026. So we are well past 2025. This did not happen. 2030 was set by the international community as the year to forget about human trafficking and slavery in total all over the world. We are just 4 years from that year. Of course, that will not happen. So this actually suggests how difficult it is to fight against these phenomena, and the international community, even though many important things have already been achieved, but is still struggling to do that. Now we are switching to the reasons for this strong gender dimensions of slavery and human trafficking. Here on the slide, you have some causes, some reasons why this gender dimension is so present when it comes to slavery and human trafficking. Of course, there are some others. This is not an exclusive list, but these are the most frequent and most important ones. First of all patriarchal culture. How does patriarchal culture contribute to gender dimensions of human trafficking and slavery? What do you think?
The idea of subordination of women,
that's right,
makes it that subordinate. So
that's right.
And you have the owner, the controller, and
right.
Then
that's right. Excellent, Dushanka. Poverty. How does it contribute to making women more vulnerable to human trafficking? Have you heard about the concept of feminization of poverty? No?
Yes.
Yes. Una, can you explain it to us?
Well, basically, when we talked about it a little bit in classes, for example, when we talk about the lowest paying jobs, we are always talking about women-dominated field, for example, education or care giving jobs. So if you see a job that is women-dominated, then it's the lowest paying job, basically.
That's right. So actually, the poverty of women is more severe usually than of those of men. And there is an increase as well. You know, according to UN Women, you are familiar with that agency of the United Nations, the majority of the 1.5 billion people living on $1 a day or less are women. And worldwide, women earn on average slightly more than 50% of what men earn. So these are global data, global figures, which, of course, contributes to making women more vulnerable of becoming victims of slavery-like practices and human trafficking. Una already mentioned the lack of viable employment opportunities. Why is it also a root cause for these gender dimensions of slavery and human trafficking? Because then women tend to work in some informal sectors where they are more prone to becoming victims of exploitation and trafficking as well. Education, a very relevant aspect. Una mentioned it, but I have some interesting, but again, terrifying figures for you. You know, worldwide, 129 million girls are out of school. These are data coming from UNICEF. So again, an agency of the United Nations. Only 49% of countries have achieved gender parity in primary education. Only 49%. When it comes to secondary education, the gap widens because 42% of countries have achieved gender parity in lower secondary education and only 24% in upper secondary education. So you can see that this is very problematic. And why do girls, why don't they go to school in the same numbers as boys do? In poor societies, families tend to send to school who? Boys, sons, not daughters, not girls, which then again makes them more vulnerable to becoming victims of human trafficking. Gender-based violence and cultural norms that normalize such violence are also considered a root cause for making women more vulnerable to slavery. Some research has shown that it is very often that victims of human trafficking and slavery-like practices have had some former experience of gender-based violence, which makes them more vulnerable to entering the chain of trafficking. Of course, it goes without saying that conflict situations, wars, again, also contribute to making women more vulnerable. And we can say that all these causes, they existed throughout the years, throughout the centuries. So they are old causes and roots for making women vulnerable to slavery-like practices. Whereas something that is new is migration. Migration, and I will talk about that towards the end of the class. Migration is something that exacerbates even further the vulnerability of women to become either victims of human trafficking or of slavery. But this is not the end. So far we have talked that women are vulnerable, and what are the reasons that women are more vulnerable to these slavery-like practices. But not all women are equally vulnerable. The ones we are sitting here, we are not as vulnerable as some other women with some other identities or characteristics. So what needs to be always taken into account is intersectionality. So you always have to have in mind this intersectionality approach based on intersectionality, because there are different layers of vulnerability. Have in mind a woman, and then add that this is a poor woman. Then to that, add that this is a poor and uneducated woman, or that this is a poor, uneducated, and unemployed woman, or that this is a migrant woman, or a woman with disability, either physical or mental disability. On the top, that it is a minor. But this is not the end. Can you give me some other layers of vulnerability that you cannot see on these slides? There are many of them.
Women from rural areas.
Excellent, Elena. That's right. What else?
Or but speak the language.
That's right. Not speaking the language is another layer of vulnerability. What else? Take stateless women. Legally invisible women who do not have documents, homeless women. If we switch to girls, just imagine how vulnerable are girls from foster homes, or women who are drug addicts. So you can see how many different layers of vulnerability there are, and they make certain categories of women, certain groups of women, even more vulnerable than women in general. Now we come to the more boring part, but I hope that I won't bore you you too much, but we have to do the legal thing as well, legal documents. So now is the time to actually differentiate legally between these different concepts, because I mentioned slavery, I mentioned human trafficking, I mentioned slavery-like practices. There is also the concept of servitude used by some international conventions, and they all mean different things from the law perspective of talking. So what we will now be dealing with is actually which international conventions forbid these practices, how to differentiate between these different concepts, and then we'll see whether these instruments, these international conventions, contain any gender-sensitive rules, and what are these rules. So let's begin with slavery, because it is the oldest phenomena, and actually, as I mentioned earlier, the oldest convention. It all started with the 1926 League of Nations Anti-Slavery Convention. 30 years later, the Supplementary Convention on the Abolition of Slavery, Slave Trade, and Institutions and Practices Similar to Slavery was adopted. So these two instruments, when it comes to slavery and slavery-like practices, are specialized instruments, which means that these are international conventions, particularly, especially dealing with the institution of slavery and slavery-like practices. On the other hand, do not forget that we have human rights treaties. Human rights conventions, they contain a specific provision prohibiting slavery and servitude, and you will see forced labor, etc. So the most important ones are the Universal Declaration of Human Rights, the International Covenant of Civil and Political Rights, and the European Convention on Human Rights. They all have a particular provision prohibiting slavery and servitude or slavery-like practices. So let's start with these specialized international treaties. The 1926 League of Nations Convention against slavery. How does it define slavery? It says, slavery is the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. So what can we see from this? What can we conclude from this definition? The main feature of slavery is ownership. So it's, in a way, having property rights over another person. But ownership needs to be there to legally, from the legal perspective, qualify a situation as slavery. Complete control a person exercises over the victim. Slavery-like practices were covered within this definition, but what we can also observe is that slavery is the status or condition of a person. So the language used in this provision is gender neutral. It does not make a distinction between women, men, whether women are more vulnerable to becoming slaves, etc. As I said, 30 years later, we have a supplementary additional convention to the one in 1926. And there you have a whole new article, Article 1, which deals with slavery-like practices that target women, whose victims are always women. And you can see that it prohibits any institution or practice whereby a woman without the right to refuse is promised or given in marriage. This is something that is still happening. The husband of a woman, his family or his clan, has the right to transfer her to another person for value. Simply sell a woman to another man or person. A woman, on the death of her husband, is liable to be inherited by another person. Inheriting women, the practice of inheriting women, also a slavery-like practice. So, marriage without consent, prearranged marriage, transfer to another man, or inheriting women these practices were, in 1956, considered as practices that especially target women as victims and that need to be accentuated and prohibited through a new convention, that the 1926 convention, which prohibits slavery, was not enough, that it was needed to have another document, another instrument, explicitly forbidding these practices. What did I tell you? When were these two instruments adopted? 1926, 1956. Now have a look at this. This is a testimony coming from one girl from the so-called Trokosi tribe in Africa, in West Africa. And this was this statement was taken by Anti-Slavery International in the year of 2000. So not that long ago. And you can see what she said. She said, I was sent to the shrine when I was 9 years old because my grandmother stole a pair of earrings. I was made to work from dawn until dusk in the fields, and when I came home, there was no food for me to eat. When I was 11, the priest made his first attempt to sleep with me. I refused and was beaten mercilessly. Other girls in the shrine told me it was going to keep happening, and if I refused, I would be beaten to death, and the next time he tried, I gave in. The suffering was too much, so I tried to escape to my parents, but they wouldn't accept me and sent me back to the shrine. I couldn't understand how my parents could be so wicked. Were you familiar with these Trokosi practices in Africa? Have you ever heard about it? No. Actually, what is the idea? You know, the family thinks that they will be pardoned for their sins if they send their daughters to the shrine. And it may continue like this through generations, depending on how serious the crime was. So what I wanted you to have in mind, even though we are talking about rather old international instruments, 1926, 1956, these practices are still there. They still happen somewhere in the world.
There is also the Bacha, I think. And that is actually similar. I mean, in a way, it's similar, but they are selling their voice and they protocol.
Yeah, that's right.
That's the poverty there.
That's right. But this example, the example you gave, they were not from Europe. One would think that in Europe things are different, that there is no slavery in Europe anymore. Still, you know, when the European Convention on Human Rights was adopted in 1950, one particular provision was dedicated to slavery. And you have Article 4, which says very concisely, no one shall be held in slavery or servitude. And paragraph number 2, no one shall be required to perform forced or compulsory labor. Now what I want you to do is pay attention to the legal, again, differences between these concepts. So what do you have here? We have 3 different practices. We have slavery, we have servitude, and we have forced labor. So these 3 concepts are forbidden by the European Convention on Human Rights. Again, the language is gender neutral. No one shall be held in. How does the European Court of Human Rights define these concepts? Because you see the provision, it's brief. It does not explain what is slavery, what is servitude, what is forced labor. It does not tell that. But thanks to the practice of the European Court of Human Rights, we got a distinction. Now we know what is slavery, what is servitude, and what is forced labor. When it comes to slavery, the European Court of Human Rights simply says the 1926 Convention definition applies. So slavery in Article 4 of the European Convention is considered in the same way as slavery in 1926 Convention, which was, let me check whether you were attentive enough. How did the 1926 ownership? That's right. So exercising either all or some of the elements of ownership over a person. Excellent. But servitude is a new concept. We did not have servitude in the 1926 or 1956 Convention. So what the court said, so it defined it itself, it said, what is prohibited is a particularly serious form of denial of freedom. It includes, in addition to the obligation to perform certain services for others, the obligation for the serf to live on another person's property and the impossibility of altering this condition. So what can you see, what can you detect as elements of servitude? First, particularly serious form of denial of freedom. That is one thing. The obligation to perform certain services for another person, and the obligation of serf to live on another person's property, and impossibility to change his or her situation. Can you compare it to slavery? What is the difference? No ownership, but only that. In other parts, actually, it is very similar to the situation in which a slave is held, but without ownership rights over a person. The third concept is forced labor. There, the European Court of Human Rights refers to the International Labour Organization Convention on the Abolition of Forced Labor, the 1930 Convention, and it defines forced labor as all work or service which is exacted from any person under the menace of any penalty and for which the person has not offered himself voluntarily. So there has to be a threat of penalty of some kind to a person, and that the person does not perform this work voluntarily. It is coerced to do that. So is this clear? Can you now distinguish between these three concepts? Slavery, ownership, servitude, a particularly serious form of denial of freedom, the obligation to live on one's property, and the impossibility to change that situation, and the forced labor, threat of penalty, and the person did not offer himself or herself voluntarily to that labor. Now I have a first case study for you. So this is a real case. The girl that you can see on the photo was actually a victim, and her case ended before the European Court of Human Rights. So S, that's her surname, Miss Siliadin, is a citizen of Togo. She was 15 years old when she came to France, accompanied by Mrs. D. The deal was that she would help Mrs. D in household chores until she pays off the cost of the plane ticket. Mrs. D pledged to resolve her immigration status and enroll her in school. Mrs. D took away S's passport upon arrival in France, and she lent her to Mr. and Mrs. B in order to help them with their 2 children. S worked 7 days a week without a day off. Only on Sundays was she allowed to go to church and attend Mass. She didn't get paid. At one point, S managed to get her passport. She confided in her neighbor about her situation, who informed the Committee Against Modern Slavery. They submitted the appropriate request to the prosecutor's office. Mr. and Mrs. B were acquitted upon trial because slavery and servitude were not as such classified as offenses under French criminal law. Just imagine this happened in 2005. So it was. How is that possible that then it's not possible? It actually was possible. So my question now, did you get the facts of the case? Okay, my questions are the following. So this is the famous case, landmark case, Siliadin versus France, before the European Court of Human Rights. My first question is, how would you qualify the situation in which the girl was held? Was it slavery, servitude, or forced labor? Or maybe several of them, or maybe all of them? What do you think?
I mean, it's slavery and servitude.
Mm-hmm.
I think it was more of servitude.
Okay.
Slavery,
Okay.
just because of, but I'm not sure because do you need a local paper that acknowledges the ownership?
No, of course not. I mean, you cannot have it. It's illegal. I mean, it would be useless to have such a paper. But the effects of the situation.
Mm-hmm. Because of you.
Mm-hmm.
But I mean,
what about forced labor?
I wouldn't say if we had a definition. I think that it doesn't seem involuntarily entirely because she. I mean, at first.
Okay, but at first she thought that her future in France would be completely different.
I think that the part of the sentence is not obliged to her. That she wasn't forced
to what? Do what? To work?
No, yeah.
Mm-hmm.
I mean, I don't know.
Mm-hmm.
Maybe it's both.
I don't expect basically her passport was taken away, so there was no other option for her as to do what they were saying.
Just imagine a minor, a girl in a foreign country, doesn't know anyone.
This is
The
then she got what she accepted to do for the contract. So I would say for the because also I think when she would run against it or like like I don't want to do this anymore, I would definitely be a
Myla, excellent. You are thinking the way the European Court of Human Rights was reasoning. But I know that our colleagues online cannot hear you. I mean, they could not hear your answers. Any ideas there? Do you have any ideas? You who are online, would her situation be qualified as slavery, servitude, or forced labor? They went for a break.
We're here, but
Yes, we're here, but
I'm not sure.
But you're not sure. Okay.
Yeah, because there is no concrete ownership, but she took her passport. So in a way, she limited her in her movement. Also, I don't know, when we talk about forced labor, she made a deal, so she was not forced, but also she is a girl, so I don't know if she
didn't make a deal, to be paid, and this lady, she promised her that she would regularize her stay, that she would be attending school in France. What was promised to her was something completely different.
Yeah, she tricked her, and she's was also a girl, so she couldn't reason it properly. I mean, her mental state as a minor is different than a person who is adult. So I'm not sure how to qualify it.
Okay, and then all your thoughts and reasoning are actually correct and fine. Your reasoning in the way the European Court of Human Rights reasoned. So the court said, as you can see, this is no slavery. So when it comes to slavery, the court said, although the applicant in this case was clearly deprived of personal autonomy, the evidence does not indicate that she was held in slavery in the strict sense of the word. Mr. and Mrs. B did not exercise any right of ownership over her, which would reduce her to the position of object. So that was the reasoning of the court. We do not have to, accord with the court. We can think differently and provide different argumentation, but this was the position of the court.
But wasn't there in the text of the case study, wasn't there a sentence saying that they borrowed her?
Lent her to Mrs. B, yeah, there was.
So that's she's a property, borrowing, lending someone.
Suggest that, and I did not make this up. I mean, this was taken from the facts of the case in the judgment. That is something that the court used as relevant words, but still, the conclusion of the court was the following, the one that you have on the slide, at least when it comes to slavery. On the other hand, the court said that she was held in servitude. It repeated what servitude means and what are the elements for servitude. We remember the very serious being deprived of freedom in a serious way, the impossibility to change one situation, etc. And the court took into account the intersectionality aspect. So it took into account that she was a minor, that she was a migrant, so in a foreign country, that her passport was taken away from her, that she was actually threatened by saying, you don't have a passport, you are now an irregular migrant. If the police spots you on the street, they will put you in prison because you do not have any documents, your stay is not regularized. So these different aspects, the way the thing that her documents were taken, what Mila noticed, this is also something that the court took into account and said the criteria for servitude were met because she did not have any means to influence her situation and to change it. But the court also said that she was that her situation qualifies for forced labor. You remember the elements of forced labor, that there was a threat of penalty. Here, don't have a threat of penalty. Not in the literal sense of the word, but the court said, again, having in mind her position, minor, migrant, without documents, the thing that they actually threatened her with police if she was apprehended by police, that she would go to prison and then sent back to Togo, that equaled, according to the court, to this threat of penalty. And also the element that she did not offer herself voluntarily to work. I mean, did she have any alternative? Having in mind her particular situation, no. Now I will just go back to this slide with questions and take a look at question number 4, or the fourth one. Is it relevant that she was not held in slavery or forced labor by state authorities, or can states also be held responsible for slavery or forced labor by private individuals?
I really think it should be, and it's a shame that they didn't have law prohibiting it.
Of course.
So,
of course, but from the perspective of the European Court of Human Rights, and the fact that it is France who is party to the European Convention of Human Rights, it doesn't make any difference. I mean, the state did not hold her in slavery, but the fact the state did not do anything that they could to protect her from being held in servitude and in forced labor, this is relevant for responsibility of state for violation of the European Convention on Human Rights and the violation of the prohibition of Article 4. Last question, and it is always about positive obligations. You remember I mentioned that, and I insisted on those positive obligations. I'm sure other professors also within our course on international and EU law and gender equality. So Article 4 prohibits slavery, servitude, forced labor. Who is the addressee of that provision? Who has the duty to protect persons from slavery, servitude, forced labor? States, contracting parties to the European Convention. What does this concise provision of Article 4 actually mean in terms of positive obligations of states? What was France actually required to do so that its acts are in conformity with Article 4 of the European Convention on Human Rights? To have the legal framework to forbid slavery, servitude, forced labor through its legislation. What else? Does it stop there? Is it enough to have a provision in some criminal legislation, or something else also matters? What is also a positive obligation in such cases? To make those laws effective. In other words, to provide effective protection to the victim. And in case something happens, it will never happen, or it can in theory, but the state will not hold in slavery persons. This will be by private persons. But if something like that happens, what the state also has a positive duty to do? To act on it, meaning to investigate what happened, and to prosecute those who are responsible. So you can see that this brief, concise provision of Article 4, no one shall be held in slavery or servitude, no one shall be exposed to forced labor, full stop. This actually translates into very important positive obligations of states. Now that you know all that, I want you to try to give me a gender-related critique of this judgment. In a way, a feminist critique of this judgment. So I shared with you the most important elements of the case. Here on this slide of the judgment, here on this slide, you also have some excerpts. Actually, the only two paragraphs in which the court stresses the fact that she's a minor and that she's coming from another country, that she's a migrant. And that's it. So now that you have in mind the reason of the court, its argumentation, how much space and relevance it's attached to the fact that this was a young girl held in domestic servitude, doing domestic work in a European country. The fact that 3.8 million people worldwide are victims of domestic slavery, and that such a practice was very widespread in France in particular, but in some other European countries as well. So now that you have all that in mind, the specific nature of her situation, is there something that you would reproach the court, or you think that the court could have used some arguments or given some conclusions that would maybe accentuate the gender aspect of her situation? Or you're fine with it as it is? Those that are online, any ideas?
Well, I would definitely stress out more the fact that she was a minor and the manipulation, actually. I don't think that was like observed enough in this case. It is just mentioned, but in the case we can clearly see that she was promised something and then manipulated, and also threatening with the police is also some kind of manipulation. So yeah, I would pay attention to that more.
Okay. And the fact that the court treated the case as gender neutral, basically, it did not pay any particular attention to the fact that she was a girl. That this was a widespread practice back then in France, that actually the state in a way did nothing to, besides formal equality, also provide substantive equality to victims of such practices. This is something that the court did notice, but yeah, the fact that she was a girl, who is usually doing domestic servitude. Yeah.
How neighbors, what were they thinking when they seen her? What we know is that it was happening for a longer period of time. You have a person, a little girl, living in our neighbor's house, and you don't ask the question, what is he doing here? I mean, and they can have some ideas to cover themselves up.
Yeah.
But still, you can see that because she's a girl and she's there in their house, somehow she has an out, somehow that's okay, that she's a girl, and that's the domestic work, and that goes hand in hand. But still, I mean, I think they're like a couple more information.
Yeah. What the court actually, there has been much debate around this case from the perspective of feminist theories and critique. And what was also given as an argument is that the court tried to make her situation look, as exceptional, providing these arguments that she was a migrant, that she was a minor, that those were the relevant vulnerabilities that should be taken into account, but that her situation was in a way exceptional, and that it actually wasn't, because this practice of domestic servitude, as I said, especially in France, especially with such legislation where you do not have prohibition of slavery or servitude or domestic servitude explicitly in the legislation, that actually the court did not properly take into account also the gender aspects, the gender dimension of the fact of the case.
And also there is a racial element.
Racial element, that's right, which the court completely ignored. It only said she is a migrant, but again, not all migrants are in the same position. In mind, this was actually the first case, the landmark case, and that it was a huge thing that the court found established the responsibility of France, and that it started establishing positive obligations of states in terms of the legal framework of effective protection of victims, investigation. So in a way, the court back in 2005, for it back in 2005, it was enough. I mean, it thought that, this was as far as it should go. But still, I will show you later some subsequent cases where this gender analysis, gender-related analysis, is still missing in the court's jurisprudence. Okay, so here, this is what we mentioned as some potentials for gender-focused critique. It's 7:21. If we are to have a break, then now this would be a good point because we finished with slavery and servitude, and now we will focus on human trafficking as a modern kind of slavery. So what do you say? Shall we have a couple of minutes? And now I come back to Una, now that we have a break. Or Una, who did ask about World War II and
It's me.
camps? Una. So
Yeah.
what do you think? I did not forget about your question. Don't worry.
Yeah, I think it's forced labor.
Forced labor, yes, but for sure. But also there are some elements of servitude.
Yeah.
Yeah. Slavery, no, in the context of slavery as defined by the 26th Convention. But, generally, if we do not use the legal definition of slavery, I mean, these practices were as terrible as we know that it can also be qualified as slavery in the colloquial sense of the word. But from the legal point of view, labor for sure, and even some elements of servitude.
Yeah. I was thinking about that while you were presenting. And servitude and forced labor are actually slavery-like practices, right?
That's right.
I get that right? Okay.
That's right. You got it right. But as you can see in the European Convention, we have these two concepts separated because of the specific elements that they have. But they are considered slavery-like practices, just as human trafficking is. And we are going to human trafficking in a couple of minutes, okay?
Okay.
Have some coffee or refreshments, and we'll continue in 7 to 10 minutes, okay?
Okay.
10 minutes. Let's have 10 minutes break.
साइबुल भाई यदि सन এটা তুই চিন কে রান্না করা ফাকিল করা আছে
Of course, I think that Professor Tanasia will be the one conducting the exam. So you should talk with him regarding these issues that Dushanka and we're now discussing, because I'm in charge of examination of this course, International and EU Law and Gender Equality, whereas Professor Marinkovic will be in charge of examining you for this course. So talk to him. Okay. Did you have enough time to take a break? Ready to continue?
Yes.
Okay. So now we're moving to what is actually the modern form of slavery, even in the words of the European Court of Human Rights, as you will see, and this is human trafficking. So I already mentioned human trafficking several times so far. So the time has come to see how and through which instruments it is regulated at the level of international law. There are two most important treaties. The one is universal, and this is the famous Palermo Protocol to prevent, suppress, and punish trafficking in persons, especially women and children, which is actually an additional protocol to another international treaty, and this is the UN Convention Against Transnational Organized Crimes. So if you have an additional treaty that deals with human trafficking, so which is an additional document to the one dealing with transnational organized crime, what does it suggest? To which forms of human trafficking does this relate? Only to human trafficking, which is organized by organized criminal groups and which is transnational in its characteristics, where there are crossing of borders in terms of recruiting victims of human trafficking. On the other side, at the regional level, the level of the Council of Europe, there is a particular special convention, the Convention on Action Against Trafficking in Human Beings. And the difference between this universal and regional mechanism is that the latter relates to all situations of human trafficking, whether it is conducted by a single person or an organized criminal group, whether it is only within national boundaries or it involves an international, transnational element. Regardless of that, it relates to all situations of human trafficking and to all victims of human trafficking. Okay? So this is the main difference between these two instruments. Another important difference is that for the supervision of the regional instrument, there is one expert body called GRETA. Have you ever heard about GRETA? So it is a committee of experts, people who are really experts in protecting human rights, in dealing with human trafficking, and they can do what? They can go visit any country which is party to this Council of Europe Convention Against Human Trafficking and see what its legislation is like, whether it is in line with the taken commitments. What are its practices? Whether its judgments are in line with what is required of that state by its international commitments. How are victims of human trafficking treated by relevant state bodies? So this expert body can do that, come to visit a particular state party, check what is good, what are good practices, what are bad practices, what needs to be changed, and then issues a report to that country saying you need to modify, change in your practice and legislation, this, and that. So within the regional system, you have this monitoring mechanism. On the other hand, at the universal level, there is no such thing. So states simply take commitments, and that is that. Whether they will fulfill them or not, there is no one to monitor that, okay? I will focus on the Council of Europe instrument because it is, as I said, more developed and with this monitoring mechanism, which is very important. This convention relies on 3 P's. P number 1 is prevention. So it has a set of duties for state parties which deal with prevention of human trafficking, measures that they need to take in order to prevent persons becoming victims of human trafficking. The second P is protect. Protect who? Again, victims of human trafficking. What kind of protection can be given? Medical, legal advice, legal aid, counseling, residence permits, if those are foreign nationals.
Safe shelters.
Shelters, that's right. Translation services. So quite a number of different protection measures that states need to offer to victims. And the third P is to prosecute. Prosecute who? The traffickers. That's right. So the convention also has a set of provisions that deal with prosecution of traffickers. This is very important, and please remember this. Human trafficking has 3 elements. They all need to be present for a situation of a person to be qualified as human trafficking. This is an act, this is means, and the purpose. So all 3 elements need to be present. Act. What is an act? The recruitment, transportation, transfer, harboring, or receipt of persons. So a particular act through which a person is actually becomes a victim of human trafficking. But there needs to be specific means how a person is ending in the chain of human trafficking. Through the threat or use of force, or other forms of coercion, or abduction, or fraud, or deception, abuse of power, or a position of vulnerability, or giving or receiving of payments or benefits to achieve the consent of a person having control over another person. So you can see that there is quite a list of very different means through which a person can become a victim of human trafficking. Maybe you associate victims of human trafficking with abduction, but according to some research and analysis, this is actually the rarest means to become a victim of human trafficking. This abuse of vulnerability, abuse of power or control that one person, the trafficker, has over the victim is most often the case. And the third element is exploitation. Exploitation meaning what? Very different things again. Exploitation of the prostitution of others, or other forms of sexual exploitation, forced labor, or services, slavery, or practices similar to slavery, servitude, or the removal of organs. So these are all different exploitation options. So these 3 elements need to be present. there is one exception when it comes to children. Which of these elements do not have to be present when it comes to children, and why? You can see here on the slide which element, but why? Why is the means element irrelevant when it comes to children as victims of human trafficking? Because they're very easily manipulated, or you can get their consent very easily. You do not even have to use coercion or abuse of power. I mean, the abuse of power is always there, but with children, the methods are much very different than with adults. So the convention insists that there would be the act of human trafficking, the criminal act of human trafficking, when it comes to children, even if all the three elements are not present, because means does not have to be there. You have the act and you have the purpose of exploitation. When it comes to exploitation, does it have to happen? Does a person have to actually be exploited to be a victim of human trafficking? Or it is enough to have simply the intent to exploit a person. So this extent for the purpose of exploitation is enough. I will give you an example, something that's happened here in Belgrade. And I was told that story about one prosecutor for organized crime. So there were two girls from Russia, Ukraine, several years ago that happened, coming to Belgrade. The traffickers recruited them, but they thought that they were coming to Belgrade just to sleep over. This is a stop on their way to Italy, and that they would go to Italy to work in one hotel as waitresses on the sea coast, to earn some money, etc. Actually, these traffickers, they were on measures, so they were what's the word in English?
Monitored.
They were monitored by our police. Yeah, their conversations were monitored. And our police and the prosecutor's office, they knew what would happen to those girls, that the intention of those traffickers was to just simply take them to Italy to use them for sexual exploitation. So they were thinking what to do. Those girls are here in Belgrade, in one apartment in New Belgrade. So they have them on our territory. If they let them leave Italy, they might, simply lose track of them and not have control over them anymore. And then they decided to act. And they entered into this apartment in New Belgrade where these two girls were together with traffickers. They arrested the traffickers, but the girls were like, no, this is not what would happen to us. We were just going to work there to be waitresses. Did the exploitation happen? No, they were still not exploited, but there was the intent for the purpose. They were recruited for the purpose of exploitation, and that was enough for our prosecutors and police to act. So have this in mind. Okay, I can skip some of these issues to go to the most important ones. Yeah, the most important part of the Anti-Trafficking Convention of the Council of Europe is the second P, meaning protection measures. In order for a person for a victim to get protection, it first needs to be identified as a victim of human trafficking. Who does that? What do you think? Who does the identification of a victim, which is a precondition for the victim to get protection? Medical services, counseling, whatever else is there in the convention. What do you think? Who should do that?
First person who
is in contact.
Yeah.
Should be the one to, pay attention, to be trained, to be familiar with the indicators for victims of human trafficking, but not necessarily the person, who would identify it. Who can be the first one in contact with the victim? Police? doctors. Yeah. Who else?
From the
That's right. That's right. But neither of them is a licensed. Yeah. No, prosecutor. But there needs to be a licensed person to verify that the person is a victim of human trafficking. That can only be done by a psychologist, a person who is trained, who possesses relevant knowledge. So whoever is first in contact with the victim, and those are the persons that you mentioned, they need to be trained to be familiar with the indicators of to notice who might be a victim of human trafficking, and then contact the state body who is in charge for identifying the victim. For example, in Serbia, this is Center for the Protection of Victims of Human Trafficking. We have a specific body who is the only one licensed to identify a victim.
Is that a government body?
That is a government body, that's right. No, within the Ministry for work, labor, etc. Yeah, I mean, the institutionally, but it is a department on its own. So they are the only ones. The situation might be different, the solution might be different in other countries. So maybe Maya and Martin or Anastasia, you can check how it works in your countries and who is in charge to identify a victim of human trafficking in your countries. Because the convention provides that this is a duty of the state. It does not regulate how the state needs to perform that duty. But it is up to the state to do that. Once the victim is identified, then it can be given assistance and protection. What is that? Proper standard of living, emergency medical care, because sometimes, victims of human trafficking are in such bad medical condition because they may have been exploited for years. They may even be drug addicts because this is usually connected when it comes to sexual exploitation. So emergency medical care, but not only emergency medical care, counsel as well, and other kind of medical assistance is relevant translation assistance, if this is foreign national counseling, information, legal aid, etc. When it comes to children, even right to education. Victims should also, according to the convention, have rights to compensation and legal redress. This is difficult because, for example, in Serbia, I don't know how it works in your respective countries, but in Serbia, what would be a good solution is for the criminal court, during the criminal proceedings, to decide on the compensation claim of the victim. Why? Why is this better than to leave for the civil suit, for civil claim and civil proceedings to determine the validity and the amount of compensation owed to the victim for the catastrophe that she went through? Why would that be a better solution? That's right. That's right. How often do you think our courts do that? Rarely. Yeah, the criminal court rarely decides on the compensation claim of the victim. The one bright example is the appellate court in Novi Sad, where you have one judge very sensitive for trafficking cases, and the judge decided to give compensation to the victim within criminal proceedings. Otherwise, victims are simply transferred to civil proceedings, which is also a problem when you have foreign nationals, because then foreign national does not necessarily have to be in Serbia for as long as these civil proceedings last, and they might last for a couple of years. Okay, monitoring, that's what I mentioned. Now, you got the idea that human trafficking is a crime with very, very present gender dimensions. when we talked about those root causes for gender aspects of slavery, all of them apply here because human trafficking is also a kind of modern slavery and the slavery-like practice. So all those patriarchal relations, the feminization of poverty, what else did we have? Migration, war, gender-based violence, division of labor, etc., etc. All that applies here as well. But what else we should think about is that there is an obvious gender dimension regarding the form of exploitation. To which forms of exploitation are women more vulnerable to be exposed? Sexual exploitation, what else? Domestic servitude, that's right. However, when it comes to some other forms of exploitation, men are more likely to become victims. Regarding which forms of exploitation as an element of human trafficking are men more vulnerable to? Work, labor exploitation, it is usually men. Well, others, there could be both women and men as victims. But still, this is obviously a phenomena with strong gender dimensions, whether women are vulnerable to certain forms or men to others. That is why assistance needed by victims of trafficking also needs to be gender specific. Because when you have a victim of sexual exploitation, who should be working with that victim? What kind of protection measures should be offered to such a victim?
Psychologists and medical assistants.
That's right. Who should be the one, for example, giving counseling to such a victim? The woman. Translation services, again, woman. So all these different assistance, support, and protection measures need to be gender sensitive. But this might also apply to men. Regarding labor exploitation, you would be surprised how many men victims of labor exploitation as a form of human trafficking simply, deny the fact. They simply deny the idea, the possibility that they are victims, and let alone victims of human trafficking. So with regard to this group of victims, this gender-sensitive approach should also be applied and tailored in line with the necessities and specificities of a particular victim. You cannot apply general same measures to everyone. The response, the treatment, the approach needs to be designed individually, having in mind specific characteristics of each victim. Policy approaches and measures aimed at combating human trafficking also need to be gender sensitive. Essentially, all of the 3 Ps that the convention relies on, prevention, protection, prosecution, all of them and the relevant duties of states need to be applied in a gender sensitive manner. Now let's see whether this is the case. You remember the 2 most important instruments are the Palermo Protocol, the universal one, and the regional one, the Council of Europe Convention Against Trafficking in Human Beings. Take a look at the title of the Palermo Protocol. It is called Protocol to Prevent, Suppress, and Punish Trafficking in Persons, especially Women and Children. So even the title suggested that the focus was actually on women as dominantly victims of human trafficking because, sexual exploitation was perceived as the dominant form of exploitation when it comes to human trafficking. There are certain provisions. You can see Article 9, which relates to prevention, the first P, And it said that particular attention is explicitly placed on women and children. So again, focus on women approach, not gender equality approach. Article 6, assistance to and protection of victims. Now there is a slight difference. It says each state party shall take into account in applying the provisions of this article the age, gender, and special needs of victims of trafficking in persons, in particular the special needs of children. So in some parts regarding prevention, we have a focus on women approach. When it comes to protection, gender-based approach to providing protection to victims. The same relates to training. Now, if you take a look at the Council of Europe Convention, before adopting this Council of Europe Anti-Trafficking Convention, a series of acts were adopted at the level of the Committee of Ministers of Council of Europe and the Parliamentary Assembly of the Council of Europe. In all those resolutions, the focus was on women. So the idea was to have a treaty which would suppress trafficking in women and those forms of exploitation that women are mostly exposed to. And then at the end, when the treaty was adopted, there was a shift, there was a change, and the gender equality approach was adopted. In what sense? You can see here, I have it on the slide. You can take a look, a more detailed look later on when I send you the presentation. But generally, there is a general gender equality provision, and all three Ps, so prevention, protection, prosecution, they need to be gender sensitive according to the convention. Which of these two approaches do you find better? The one focusing on women, or the more general one relating and focusing on gender equality and taking gender as a relevant factor?
I think
Why?
About all gender, and I think the victims, the women, and need to take attention about it.
Yeah.
It's like a fact that our world is modern, our society is modern. If we pay attention to all genders, not only.
You can, and also, what I mentioned, human trafficking, this exploitation element can mean different things, and not all forms of exploitation target women and men equally. So there are some forms of exploitation that actually men are more often victims of. So this gender equality, gender sensitive approach to interpreting and applying international treaties in the area of human trafficking is, according to my opinion, much, much better, because it still leaves enough space to, apply relevant measures which would be in line with the needs of a particular victim, even if a victim is a woman who suffered, some catastrophic experience of years-long sexual exploitation. So this is the better solution. One more instrument, and I won't bother you with them anymore, but very important one, CEDAW. CEDAW, as I mentioned, is the Convention on the Elimination of All Forms of Discrimination Against Women. As you can see, so it is the international treaty for women's rights, the most important one. I'm sure you mentioned it with Professor Kustic, probably even with Professor Marinkovic within this course, but we also mentioned it during the international and European law and gender equality course. One provision, Article 6, is specially dedicated to women trafficking. It says state parties shall take all appropriate measures, including legislation, to suppress all forms of trafficking women and exploitation of prostitution women. Important provision, but Even more relevant is what we got from CEDAW in form of General Recommendation number 38 from 2000, where the CEDAW said that actually trafficking in women is a form of gender-based violence. So the court qualified, the CEDAW committee qualified trafficking in women as a form of gender-based violence, which is also a form of gender-based discrimination. And the committee considers it a norm of customary international law. Why is this relevant? Why is this qualification of gender-based violence, and through gender-based violence also trafficking in women, as a customary international law relevant? Who is then obliged by such a prohibition and the obligation to suppress gender-based violence and trafficking in women? All states, regardless of whether they are contracting parties to this or any other treaty. So customary international law obliges every state. So this is very, very important. But also in terms of qualification of trafficking in women as gender-based violence, this general recommendation is very, very important. And now I come to the second case study. This slide is here just to remind you about the formulations and concepts contained in Article 4. So prohibition of slavery, servitude, and forced labor. Is there human trafficking in this provision? Not explicitly, but as you will see from the case that I have, now the court qualified human trafficking as modern kind of slavery and said that even though human trafficking is missing from Article 4, it is implicitly there, meaning that all positive obligations that states have according to Article 4, you remember, obligation to put a proper legislative framework, to provide protection, effective protection to victims, to investigate cases. These positive obligations also apply to victims of human trafficking and to human trafficking in general. The jurisprudence and the case law of the European Court of Human Rights when it comes to human trafficking is unfortunately growing, which is not a good sign. It means that we are still living in societies that in which human trafficking happens. As opposed to slavery and servitude, those cases in the case law of European Court of Human Rights, they are not that frequent. Siliadin, the one that I mentioned, is one of the few. On the other hand, when it comes to human trafficking cases, in the case law of the European Court of Human Rights, there are many, many cases relating to human trafficking, and the number is unfortunately growing. It all started with the one that I will focus on, and this is the landmark case of Rantsev versus Cyprus and Russia. We have Anastasia here from Russia, so this is the case that also related to your country. You can see that it was back in 2010, but still a landmark case because of what the court said. This is the girl, Oksana Rantseva, who was the victim of human trafficking, and this is her father. Unfortunately, she lost her life. She was found dead in Cyprus. I will give you the facts of the case. So she was not able to, submit the application, but her father did that, and her father took both Cyprus, the country in which she was exploited, and Russia, the country from which she was recruited, to the European Court of Human Rights. And the case is a bit complex and complicated, but this is the essence of the facts. So a 20-year-old Oksana was admitted to Cyprus on a so-called artist visa. The visa was procured for her by an owner of a cabaret and allowed Oksana to work in that cabaret. It is general knowledge in Cyprus that these artist visas are in practice a gateway into prostitution, even to the degree that the word artiste has become synonymous with the word prostitute. After working for a few days at the cabaret, Oksana left her apartment, leaving a note saying that she was going back to Russia. A few days later, she was found by somebody who contacted the brother of the owner of the cabaret. He brought her to the police, alleging that Oksana was illegally in Cyprus and that the police should hold her in the cell. He then left. The person in charge of the police station gave the order that the owner of the cabaret should be contacted and ordered to collect Oksana. The brother of the owner came back to the station, picked her up, and brought her to the apartment of one of his employees. They put Oksana in a room on the 6th floor and allegedly left her alone. Sometime later, she was found lying dead on the street below the apartment. The Cypriot authorities started an investigation into her death, which gave no results. Did you get the fact of the case? So, how would you qualify her situation? Remember that Article 4 does not contain human trafficking. Yet, she's an obvious victim of human trafficking. There is the act, recruitment in Russia, through the means abuse of her confidence to come to Cyprus. She meant that she thought that she would be working in a cabaret as a dancer, didn't know what was to happen to her. And finally, the third element, exploitation. However, as you remember, in Article 4, we do not have human trafficking explicitly. But the court resolved this by saying human. You have here the excerpt, the citation from the court's judgment. It says, the court considers that trafficking in human beings by its very nature and aim of exploitation is based on the exercise of powers attaching to the right of ownership. It treats human beings as commodities to be bought and sold and put to forced labor, often for little or no payment, usually in the sex industry, but also elsewhere. It implies close surveillance of the activities of victims whose movements are often circumscribed. It involves the use of violence and threats against victims who live and work under poor conditions. And it continued, it said, trafficking itself within the meaning of Article 3 of the Palermo Protocol and Article 4 of the Anti-Trafficking Convention falls within the scope of Article 4 of the Convention. So it was a huge thing that the court interpreted the European European Convention of Human Rights, specifically Article 4, that it implicitly also prohibits human trafficking because the court qualified human trafficking as a modern kind of slavery. As I said, what does this actually mean for the contracting states? That they are required to respect and fulfill all those positive obligations that are associated with Article 4. And those are the positive obligation to put in place an appropriate legal framework, the positive obligation to take protective measures to protect the victim, and the procedural obligation to investigate trafficking. Now, what I want from you, you remember, we have two respondent states. We have Cyprus and we have Russia. Let's now focus on Cyprus. Did Cyprus violate any of these positive duties that you see here?
By not doing anything.
Which ones? All of them?
When she spoke to the police, they called the owner of the cabaret to collect her, which was like, getting into the factory, joining it.
If I tell you, because these were brief facts of the case, but if I tell you that when they took her to the police, she was disoriented. It appeared that she was drugged. she tried to ask for help, and they ignored because they were obviously in contact with those persons who owned the cabaret. So the police was actually working with them. You know, they called them and said, "No, we cannot keep her here. She's your concern. Take her and then bring her again in the morning." Just imagine doing that when you have a person who is completely disoriented and suggesting that something happened to her. So you are right. This was the argumentation of the court when it comes to the second positive obligation, offer effective protection. That was the situation in which the state could have reacted and offered her relevant protection. It did not. What about the first positive obligation, the normative legislative framework? Was it in line with what was expected from states?
I would say also not, because if they had a knowledge of so-called happenstance, right? If you know something is happening, those kind of things, you know what you should do.
That's right.
So the framework was not.
What if I tell you again, additionally, that the Commissioner for Human Rights of the Council of Europe, prior to this case, reacted to Cypriot authorities, and in its report, it said this practice that you have regarding artistic visas to bring girls from foreign countries to Cyprus to work in cabarets, actually this is prostitution behind it. So you have a body of the Council of Europe, Commissioner for Human Rights, approaching state, and state does nothing. It still has in its legislative framework something that enables the migration for the purposes of exploitation of foreign nationals. So this positive obligation also. Investigation, the third one, procedural obligation to investigate. They simply said this was an accident. This is not effective investigation. They did not look into the allegations of human trafficking. They just investigated her death, how it happened, what happened to her, but not what actually led to her being dead. What about Russia? So the situation is now completely different when it comes to Russia. But what do you think the court said? Again, we have these three positive obligations: legislative framework, providing effective protection to the victim, and procedural obligation to investigate the case.
I would say because of the knowledge of this artist visa, there should be something done by Russia beforehand, that like if somebody has this kind of artist visa going to Cyprus, that they have been like looked into this kind of stuff more.
Well, yeah, but this is something that happens in another country. You know, you cannot ask every person that wants to leave the country, where are you going, on what basis, who are you going to see? I mean, that would be too much of a burden to ask from a state. So what the European Court of Human Rights usually does is check what is reasonable to be expected from a court to do in a particular case. So the court said the first positive obligation, there was nothing Russia could do. I mean, she traveled to another country. They do have those leaflets, on the borders. Pay attention when you travel. You will often see those leaflets, warning about human trafficking. You usually have some phone numbers to report to, etc. So this is something that country did. And the court said, well, there was nothing much more that they could do. Regarding the second positive obligation to offer protection, were Russian authorities in the position to protect her from something that happened to her in a foreign country? But she did not.
Yeah.
So there was nothing they could do there as well. Still, when it comes to the third positive obligation, the court thought differently and reasoned differently and said, well, you did not do everything that you could to investigate what happened to her while she was in Russia. How was she recruited? Especially, again, I mean, you could not have the entire, the full fact of the case, but if I tell you that the father was in contact with another two Russian girls who were with her in the cabaret, they went back to Russia, they contacted him, they gave him relevant information. Then the father asked Russian authorities to investigate that. They did not want to go into those issues. They said, it happened in Cyprus. Cyprus is doing their investigation. We do not want to intervene. So this was something that the court said Russia should have done, and that they violated this third positive obligation to conduct relevant investigation. Now that you know all that, for the end, just before we try again to give this feminist critique of this judgment, I would just like you to know that the word woman and women in this judgment of the European Court of Human Rights was mentioned 94 times, but mostly in the part of the judgment where it goes through relevant legislation, international conventions, reports of different international bodies, national law, etc. When it comes to this operative part of the judgment, the courts only use the word woman or women 8 times. And in all those cases, it's actually referred to the reports. It was citing the reports of other bodies, Cypriot Ombudsperson and the Council of Europe Commission for Human Rights. The messages, the court never paid attention to the fact that she was a woman and that human trafficking for sexual exploitation predominantly targets women. Now that you have that in mind, again, my question would be, do you see any space for improvement? Now that you know the reasoning of the courts, the basic facts about the judgment, and even excerpts that I gave you, the fact that the court did not pay any attention to her gender, and the fact that human trafficking, especially human trafficking for sexual exploitation, has this strong gender dimension, do you think that there is space for criticizing the approach of the court? You are also invited to participate in this, those who are online. Any ideas? Do you think that the court should have stressed her vulnerability? The fact that she was a foreign national, a young girl.
I think he was really sure about this case because it was like a practice visa, and she thought that it's something what documents and things like she couldn't explain it, or couldn't imagine that it can be.
I think that one is also women who are, and then that is going to be key. That she is not only a woman, so maybe that can also be added. But she wasn't. I mean, not lessening her experience, but also broadening it up. Yeah, showing that this is not that happened once, but I mean,
it was obviously a pattern, a systematic practice which was tolerated by the state. The state couldn't. The state must have known about that and was aware of it. And still, you know that her case was just treated from jurisdictional and procedural issues, investigation, whether the investigation was effective, but the court never paid attention to whether different layers of her vulnerability were taken into account by the state authorities. Also, when it comes to positive obligations, is there room to interpret these positive obligations not in a gender-blind manner, which the court did, but also in a gender-sensitive manner, especially when it comes to the second of positive obligation, the obligation to offer positive to offer effective protection. You remember the international conventions that regulate this. The court did rely on those conventions, on Palermo Protocol and on Anti-Trafficking Council of Europe Convention, to read human trafficking into Article 4. But it did not, or it still has not, read gender-sensitive provisions when it comes to protection of victims and prevention also into positive obligations within Article 4. However, we must have in mind that this was the first case. The first case, it is always that the court focuses on some aspects. It does not pay attention to, it cannot go too far. So at that point, remember, this was a case from 2010.
No.
At that point, this was huge because the court qualified human trafficking as modern slavery and as included in Article 4. That was already enough. So it would be at that point too much to go into gender-sensitive interpretation of positive obligations of states. But in my opinion, this is something that should start to happen in the future cases. However, it still hasn't happened. Since 2010, you could see we had quite a number of different judgments. None of them is gender sensitive or qualifies positive state obligations in gender sensitive terms. But that is something that the court is constantly criticized for not being able to formulate those positive obligations and its reasoning in the way to take into account somehow the strong gender dimensions of human trafficking cases. Of course, I'm talking here about human trafficking cases that involve sexual exploitation, but the court also had some human trafficking cases that related to labor exploitation, where victims were exclusively men. Even in those cases, it did not read these gender-sensitive interpretation into provisions of the European Convention. So this is something that the court should start doing, in my opinion. For the end, because we are approaching the end of the class, you remember that I sent 2 documents to you. One is an article that some I will just briefly discuss this because we have this general recommendation of the CEDAW committee. Currently, there are 281 million migrants in the world. And if you remember from one of the first slides, there are 50 million people who live in some form of modern slavery. And these 2 figures, they overlap. So one part of this 50 million is within these 281 millions of migrants and vice versa. Of course, the exact numbers are not known. What is the feature of migrants when it comes to human trafficking? Vulnerability. So they are especially vulnerable to human trafficking And we have several questions: where, when, which, who? Which categories of migrants are more vulnerable, and what should states do? What should be the state's obligations when it comes to migrants as potential victims of human trafficking? Where and when are migrants the most vulnerable? Well, basically everywhere and always. When they leave their country of origin, in the transition or transportation phase, or in the country of destination, they can also be very vulnerable to human trafficking in the country of destination. What makes them additionally vulnerable is that they are far from the eyes of the states, of relevant bodies that could be able to offer them some support, because migrants usually, use some alternative routes. They are trying to hide from the officials because otherwise they would be, put in prison for illegally crossing the border, not having documents, etc., etc. This makes them especially vulnerable. Which categories of migrants are the most vulnerable? Women, of course, but you can see here on the slide other categories as well. Children, especially unaccompanied children. But among unaccompanied children, you have also unaccompanied girls. Just imagine how vulnerable to human trafficking those girls are. Adults as well, undocumented migrants, those that do not have regular status. Migrants with visas, other mechanisms that give traffickers, employers, and package control. Artistic visas from the case that I discussed earlier. Migrants traveling alone with a history of violence, with disabilities, with experience of smugglers, etc., etc. You can see that, again, even within this migrant population, we have different layers of vulnerability that then are very important for exposing the person to becoming the potential victim of human trafficking. And now I come to this general recommendation number 38 of the committee of the CEDAW committee. And you remember Article 6 that asks the states to take all the measures that they can to suppress all forms of trafficking in women. This general recommendation actually stresses that the vulnerability of women is exacerbated in the situations of migration, that the migration context makes women even more vulnerable to becoming victims of human trafficking, and that they are vulnerable in every stage of the migration cycle. Again, in the country of origin, in the transit countries, every transit country that they need to go through in order to come to the country of destination, and also in the country of destination. So, according to the CEDAW committee, migration context exacerbates the vulnerability of women to become victims of human trafficking, and this is the case along the way. So, from the country of origin to the country of destination. The most important thing that we got from the CEDAW committee are obligations of states. So how the CEDAW committee interprets and which obligations it identifies when it comes to state parties of the CEDAW Convention when it comes to victims of human trafficking. The first one is that states should pay attention that women who migrate do not become collateral damage. In what way? That they are arrested simply because they are traveling without documents or crossing borders illegally. So that, or that they are engaged in prostitution. So what usually happens? You have a victim of human trafficking who is being exploited for sexual prostitution. What happens to her?
If she ends up in jail?
If she has a contact with the police. The police would put her in jail and prosecute her for prostitution. So the committee says states need to be aware that among migrant women who are engaged in prostitution, there is a high risk, very big probability that they are victims of human trafficking, and that they should be aware of the indicators of to recognize among this population of migrant women, especially those engaged in prostitution, victims of human trafficking. How can states do that? How can states make sure that their state bodies, relevant bodies, police, whoever else may be in the contact with the potential victims, properly recognize victims of human trafficking? Training.
Education trainings, yeah. Sorry, I was too late to say that.
That's right. That's right. So training is essential, you know. It was in November that I participated in one seminar with our border police and officers of the Ministry of Internal Affairs. The aim of the seminar was to train them how to how to apply and which are the indicators for victims of human trafficking within migrant population. So there are different protocols. For example, the European Union Asylum Office has developed very useful protocols and even user-friendly applications for migration officers and border control officers to that end. So training is essential. Also applying gender-sensitive approach, the multidisciplinary approach, because this is something you, Dushanka, mentioned. Various professions can be first in contact with the victim of human trafficking. So what there needs to be is cooperation and coordination among all those stakeholders. So not just police, but also the prosecutor, also the doctors, also social services, also NGOs. They all need to be in contact and cooperate closely in order to give a proper response and identify the victim. And what is also relevant, especially in the migration context, something that CEDAW committee stressed, there needs to be cooperation between asylum authorities and those in charge for identifying victims of human trafficking and for offering support to victims of human trafficking. Why? Because you could have a person who asks for asylum in your country. So that would be the person to first be in contact with the asylum officer. The asylum officer, if he gets an information from the victim, suggesting that this is a victim of human trafficking, what this asylum officer needs to do? To contact the service that supports victims of human trafficking and in charge of identification of victims of human trafficking. This is exactly what happened in the case study 3, and this is the end, I promise. So the famous landmark case of Zeng versus the Netherlands. This was actually the problem. Lack of communication between asylum authorities and state authorities in charge of identifying and prosecuting or protecting actually victims of human trafficking. So what happened here is that the applicant was a minor Chinese national seeking asylum in the Netherlands. She was born in China, where she lived in difficult conditions and received a poor education. After the death of her grandmother, she lived on the street and was then forced into prostitution. She came to the Netherlands as a victim of human trafficking, where she was brought for the purpose of prostitution. Her application for asylum was rejected because she had no documents and could not provide details of her journey from China to the Netherlands. In addition, she waited 8 months to apply for asylum. So what she argued in her complaint to the CEDAW committee is that she was a victim of violation of Article 6. You remember Article 6, suppression of trafficking in women. And she argued that the Netherlands had an obligation to protect women from trafficking in human beings and forced prostitution. She specifically argued that the asylum authorities did not instruct her to go and report to the police what she had undergone. The authorities failed to provide her with specialized legal aid and adequate protection, and that when she sought asylum, no one had treated her as she were a minor. So many failures on the part of the authorities that were in contact with her. If I just add the fact that she was pregnant at the moment when she submitted the asylum application. So just imagine someone who as a minor came to a foreign country, obviously was a victim of human trafficking. She asks for asylum in Netherlands, tells the asylum officer what happened to her, and they never tell her that she can go to the police, that she should go to the police, report that, and on that basis regularize her stay because she has that right as a victim of human trafficking. No. So unfortunately, the committee did not decide on the complaint because she did not use all the local remedies in Netherlands. You know that this is the precondition for going before any international body, CEDAW committee as well. So she did not use all the relevant legal means at her disposal in the Netherlands national law. However, because of the seriousness of this case, the committee did send a clear recommendation, not only to Netherlands, but to all parties to the CEDAW Convention, and that it said that there needs to be cooperation and communication between asylum authorities, migration authorities, in other words, and police or those authorities in charge of supporting victims of human trafficking. Otherwise, the state would be violating its CEDAW commitments, especially Article 6, which requires states to suppress trafficking in women. So this is a recommendation of the CEDAW committee concerning the complainant, that the state verifies whether the person in question is a victim of trafficking, and if so, to take measures to protect her, which was obviously not the case. And in general, that it takes measures to ensure adequate training for border police and migration officers to identify victims, to learn adequate interviewing techniques. Why is this important? Interviewing techniques, especially gender-sensitive interviewing techniques, because here you had a minor, someone who was pregnant, who just gave birth to a baby in a foreign country, who was the victim of human trafficking. So interviewing techniques need to be very, very specific and sensitive and done by someone who specializes in that. And of course, to offer counseling and inform about the procedures available to the victim. This is the last slide. In essence, any of these aspects, any of these stages in working with victims of human trafficking need to be gender sensitive. Victim identification, we mentioned that several times. Victim identification, gender sensitive victim identification, that it needs to be done by an expert, by a specialist. Woman, if you have a woman victim, then a woman. In the manner that is in line with the specific condition of the specific victim, because not all victims of human trafficking will be in the same position and circumstances. Victim assistance and protection, again, need to be gender sensitive, and we discussed that already. Access for justice to victim, as well as investigations, prosecutions, and punishment of perpetrators. The fourth one, very important. Why? During court proceedings, what usually happens when you have court proceedings for human trafficking and you have a victim of human trafficking who needs to testify, what is usually the thing, at least in Serbia?
Screening rooms.
That's right. So you need to separate the victim from the trafficker, because the victim is terrified of that person, and she needs to confront him. The master manipulator, because this is the person who easily manipulates her, and she's already vulnerable. Just imagine, confronting them. I mean, out of the question. So separate rooms. Thank you for that. What else? What else? That's right. Avoid re-traumatization. I call you again to take a look at the video that is on the beginning of this presentation. It is very, very disturbing, but also telling. We would not expect from judges or from lawyers to behave in an inappropriate manner in the courtroom. Yet it happens. So what can happen, especially coming from lawyers of the defense, lawyers of the traffickers?
Asking the appropriate questions.
That's right. That's right. Going through the previous experiences of the victim, coming with certain issues, problematic maybe, but to degrade her and also to make her testimony relevant. So this is something that is usually the case. Victim blaming, she asked for that. She wore a short skirt. Look at her, how she is dressed. This is something that she wanted. You would be surprised how often such remarks can be heard even in the courtrooms. I'm asking students from Serbia, if you are interested in this, Astra, the NGO that I mentioned, they do the analysis of Serbian court judgments in the area of human trafficking every year. And you can find such very, very problematic information in their reports. So this is something to work on. So each aspect, victim identification, support, access to justice, investigation and prosecution in court proceedings, cooperation between states, meaning what? If a victim needs to be sent back to her country of origin, there needs to be cooperation between states. The state cannot simply send her back to her country of origin. If she was recruited there, maybe she will again become a victim of human trafficking. That is something that regularly happens. So the country of origin also needs to cooperate and make sure that the victim is safe there. So the safety of the victim is the primary concern. And compensation, we discussed that, very problematic. But hopefully, with these international standards being elevated and developed, this will have to also find a way to also rectify and change some problematic practices at the national levels. But you can see that this is actually practice and phenomena with strong gender dimensions, and that this gender dimension need to be present and taken into account into different aspects of resolving this problem. Any questions? Our time is up, has been up for the last 10 minutes, but any questions or comments or whatever? Nothing? Anastasia, you want to? There are no stupid questions.
For example,
Kidnapping.
Yeah, like someone. And for example, one child, someone kidnapped him, and this man, the woman, keeps this child in their home. This child does nothing, like only live with him. Can we reciprocate things like systems slavery?
Well, yeah, if the child is in the home, it's not allowed to leave the home. It cannot communicate with anyone. While this is ongoing, that would be a kind of maybe not slavery, but servitude for sure. If some other elements are present, if there is exploitation as well, then that would also be human trafficking, regardless of the fact that you only have one person who kidnapped the child. But, kidnapping can be the act, you remember, and means, which is not actually relevant when it comes to children, but you have a kind of recruitment and you have some kind of exploitation, even without means, that would be human trafficking when it comes to children. But some other forms as well.
And we can say that this the slavery is rights of people, of person.
Maybe you can do it, or maybe you can just say that in Serbian if it's easier to you.
Ja sam kao, na primjer, ima pravo da uradi nešto, da izađe do kući. I kao, mogu da kažem da ako čovjek je ribar, da
pa slave je rob, no?
Da. Ali mogu da kažem, ako ja uzmem neko pravo od nekog da bude
Pa kažem, zavisi sve od ove okolnosti, kompletnih okolnosti konkretnog slučaja. Znači, zavisi u kojim uslovima se osoba drži, zavisi i od objektivnih i od subjektivnih elemenata i kakvim je postupcima osoba izložena od strane onog ko drži tu osobu, a i koje su lične karakteristike žrtve. Dakle, sve bi to igralo ulogu. Mislim, to što ste vi rekli je vrlo oskudno u smislu nekih činjenica, ali za kvalifikaciju konkretnu biste morali da uzmete u obzir sve okolnosti. Ali ono što jeste poenta je da biste imali ropstvo, slavery, tu mora da postoji to vršenje prava svojine nad osobom. Sad, naravno ne u smislu da imate pravni, neki papir na kome piše da je ta osoba prodata ili, znači ne u tom smislu, nego da efekti te situacije u suštini odgovaraju onome što bi bilo ropstvo, dakle to vršenje prava svojine. Servitude je vrlo slično ropstvu, ali ne mora da postoji to vršenje svojine u pravom smislu reči, nego naročito ozbiljno lišenje slobode, znači ograničenje slobode, ali naročito ozbiljno uz tu obavezu za roba da živi na određenom mestu i da ne može nikako da promeni tu svoju poziciju. Tako je. A forced labor, on ne mora nužno da podrazumeva da vi ne možete da napustite određeni prostor, ili da vam je ograničena sloboda kretanja i da ste lišeni slobode. Kod forced labor, odnosno prinudnog rada, tu imate one elemente da se osoba tome, da to nije dobro, mislim da ne radi to dobrovoljno, na dobrovoljnoj osnovi, i da joj se preti nekom kaznom. Znate, možete imate osobu koja ode svojoj kući, ali zbog te pretnje koja joj sledi se vrati i obavlja neki prinudni rad za drugu osobu svakog dana, iako ne radi to svojom voljom. Razumete da, znači, različiti su sa pravnog stanovišta u smislu definicije, to su različiti koncepti. Svaki ima neke svoje. Sad, mogu naravno u jednom konkretnom slučaju da se stekne više tih koncepta. Znači, može osoba da bude i izložena prinudnom radu, istovremeno i ropskom položaju, on servitude. I ropstvo. Kvalifikuje, da.
Samo kidnapping, to će biti i kidnapping i ropstvo, zato što on nije uspio da izađe.
Zavisi od okolnosti slučaja. Znači, zavisi od svih okolnosti i naravno zavisi od umešnosti nadležnih organa da tu situaciju kvalifikuju. I znate šta je problem? Problem je što nadležni organi idu na lakšu kvalifikaciju. Znate koliko puta vi imate trafikera protiv koga se ne pokrene postupak za human trafficking, nego za posredovanje u vršenju prostitucije. Jer je lakše ga osuditi za to delo nego dokazati human trafficking. To bi isto bilo u ovom vašem slučaju. Lakše je nekoga goniti za kidnapping samo, nego za servitude ili forced labor i tako dalje. Znači, to je problem. Problem je kod kvalifikacije. Molim. Did you leave us with our online?
Professor Lakunoch, thank you for your interesting topic.
Thank you, Laku noć. Alexander, you have a question?
I learn a lot from this.
No, I just said good night.
Good night. Good night to
Thank you for
everyone.
an interesting lecture.
Interesting, but very difficult, because these are not easy topics. However, I must warn you that next time we will still be within difficult topics. We won't talk about human trafficking, but we'll talk about torture. So very, very, very difficult topic as well. See you on Thursday evening.
See you, Professor. Goodbye and good night.
Vidimo se.
Vidimo se, Sharmarke, or Saifu, who said that.